Hello, everybody. Welcome to the Horty Springer Health Law Expressions podcast, the Blue Cross Antitrust Class Action Settlement. Show me the money. I'm Dan Mulholland, and with me is my colleague, Moises Tonak-Benia, both from Horty Springer and Mattern. What we're going to talk about today is a proposed settlement of a lawsuit that's been going on for quite some time in the Northern District of Alabama, where a class action suit was filed against Blue Cross and Blue Shield plans around the country. We're going to go into the details of that in a moment. But the reason we call this podcast Show Me the Money is we're going to try to give you some practical advice about what you should do if you're a hospital, if you're running a group of physicians, or both, to get a claim in before the deadline to be able to share in the class action settlement. Now, this lawsuit was filed back in 2008. And it alleged that Blue Cross and Blue Shield plans around the country had violated the antitrust laws by effectively carving up the country into agreed upon service areas, which the plaintiffs in this case, alleging antitrust claims on behalf of hospitals and physicians around the country, contended was anti-competitive. After a lot of back and forth and discovery that went on literally for decades, a tentative settlement was reached in that suit. That's what we're going to be talking about today, a settlement which provides for the ability of hospitals, other facilities like ambulatory surgery centers, or individual physicians or groups of physicians to file a claim in order to get a share of the settlement proceeds. So, Moises, maybe you can go into the timeline as to when the suit got filed, when the settlement was tentatively adopted, and then what happens next.
Yeah, so July 24, 2008 is when the lawsuit was filed in the Northern District of Alabama, as Dan mentioned. Then, over a decade later, on October 14th, 2024, the tentative settlement agreement was approved. And in March 4th, 2025, that was the opt-out date for most facilities. So some facilities opted to opt out and kind of take their own claims and try to, they're going to kind of do their own thing. And so since it's past March 4th, 2025, the big deadline that's coming up is July 29th, 2025. And so that is when the claim submissions are due, and that is when the fairness hearing will be held to determine the settlement agreement.
So that's a fairness hearing held in front of the federal judge in the Northern District of Alabama, correct? Mm. And the tentative settlement is some 163 pages long. And the final settlement will be approved by the judge after objections are heard and after anybody, for instance, who wants to speak about the settlement can do so. But you mentioned the opt-out date. I know a number of larger health systems had chosen to opt out. What that means is they can't share in the settlement. They've chosen to go ahead on their own and file separate lawsuits against their applicable Blue Cross plans, which may or may not be successful, but those parties are out of the settlement. But the key is this is a zero-sum game in terms of the amount of the settlement, right, Moises? Mm-hmm. So there's about $2.8 billion that was approved in this tentative settlement last October. Now, out of that $2.8 billion, all of that doesn't go to the providers. About 24% of it or so will go to the attorneys for the plaintiffs in the class action, as is often the case in any kind of class action litigation. So that drops it down to a little over $2.1 billion. And then the courts provided for about $200 million of costs and expenses in order to handle the administration of the settlement. After that's deducted, you have about $1.9 billion or so left for the providers. And the reason I'm saying or so is that there was an exact number for attorney's fees in the settlement agreement, but since there may be some objections, there may be some additional fees, we're using 24% as sort of a rounding number. So that leaves about a little less than $1.8 billion, about 1.7 and change for hospitals and facilities who will get 92% of the settlement pot. And then about another 154 million, for professionals. They get about 8% of the amount. So how does that get divided up? That's the $109 million or $109 billion connection or question. So first of all, there's a formula for hospitals and a formula for professionals. So if you have not opted out, and if you choose to file a claim, which we'll explain a little bit before July 29 of this year, they use a formula, first of all, takes the Blue Cross market share in your core-based statistical area. That's either your metropolitan statistical area, if you're in a bigger area, or a micropolitan statistical area. Those are all Census Bureau classifications. So they're going to look at whatever the parties have agreed upon in terms of the market share of the Blue Cross plans within your service area. Then they'll look at each year from 2008 through 2024. And then they'll apply something called a harm coefficient, which uses a model to estimate the relative effect of the actions of the Blue Cross defendants on different healthcare facilities. And what that does is look at the degree of anti-competitive activity that the consultants who are working to calculate this harm coefficient will determine, and they assign a point value to it. So if you were in a market where, for instance, there was a high market share, the first threshold that they're looking at, and then second, very significant anti-competitive harm alleged where you possibly, were subject to further depressed prices than perhaps other areas, you might get a higher point total. And they use this point total to adjust the total number of claims that you would be given credit for during that time period. And Moises will explain how you submit the information about your claims. It's a lot easier than you think. So they'll come up with a number that divides up this settlement pot by this formula that, apparently you could object to it, but in the end, frankly, you probably don't have much control over how this is calculated. Now, for medical professionals, they look at either individual professionals, which individuals are allowed to participate in this if you're a sole practitioner, or groups, whether they're affiliated with a hospital or not, can file a claim as well. And then depending on the amount of payments that would otherwise be given to those groups or individual physicians over the time period, they assign a point total to that. So if you got more than $1 million for a group or an individual provider over that time period, you might get 5 points assigned. And then they use a harm coefficient similar to what we talked about before to figure out how they divvy up that remaining 8% of the pool. So it's hard to tell exactly how much any individual hospital or facility or provider group would be entitled to. On the other hand, it's, in our opinion, pretty much found money. Because if you opted out, you're going to have to pay for attorney's fees to pursue Blue Cross. You might be more successful in the end. If you haven't opted out, then your only ability to share in the settlement is to file a claim. So I think there are a few different providers who are excluded from this, right, Moises?
Yes. So excluded providers are providers who, first, are providers who are owned or employed by any of the settling defendants. Second, their provider is owned or employed exclusively by quote unquote governmental entities. So that's either Native American tribes or owned by the federal government, or they're providers that exclusively provide services, equipment, or supplies to members or participants in Medicare, Medicaid, or any federal employee health benefits program. Third, they're providers that have otherwise fully released their release claims, as you mentioned, before that March 4th deadline. And then fourth, they're providers that exclusively provide or had provided prescription drugs, durable medical equipment, medical devices, supplies or services provided in an independent clinical laboratory, or services, supplies, or equipment covered by standalone dental or vision insurance.
So a couple of thoughts about that, Moises. First of all, Blue Cross plans around the country, or Blue Cross affiliated plans, will oftentimes employ physicians. So those physicians obviously can't file a claim because the employer in that case is one of the defendants. Another situation might be where a Blue Cross plan ultimately controls a hospital or a system of hospitals. That might be something where those hospitals will not be able to participate in there because effectively they'd be suing themselves if they either brought the suit or opted out and tried to sue. The governmental entities is important because a lot of hospitals around the country are owned by hospital districts or are otherwise owned by some an instrumentality of state or local government. Those hospitals are allowed to participate in the suit. It's just the ones owned by the Native American tribes or owned by the federal government, VA hospitals, military hospitals, whatever.
Mhm.
So if you're a county-owned hospital, if you're owned by a hospital district and you have not opted out, you can still participate in this. So, Moises, how did I go about filing claims? There's a couple of options, and when you look at the fine print, it's a lot easier than it might seem at first.
Mhm. So I think it's first, it's important to note that there are forms available on the providers and professionals claims like official website, www.bcbsprovidersettlement.com. There you can find a copy of the form that you would submit, and also attached there's this thing called a rider document.
There's a lot on there too, I think, isn't there? There's some webinars to explain the process, an FAQ page where you get all the information about it. So that's really the go-to spot because you're going to have to go there to get the claim form anyway.
Yeah, and that's where you're going to go to submit the claim as well, or you can mail it in at a specified address. Anyways, so for submitting a claim, there are two options essentially. There's an option A, which is the standard method. Typically, when you're filling out the form, you fill out all this information that's asked, whether it's the healthcare facility name, the type, the national provider identification number, tax ID numbers, first date of services, things like that. And then there's option B. Option B is for a specific group of claimants. Option B is for hospitals, entities, facilities that are located in Arizona, Iowa, Louisiana, Maryland, South Dakota, Care First Services in Virginia, the District of Columbia, Puerto Rico, and any healthcare facilities that were not open before January 1st, 2015. So
they're the ones who have to use option B.
they
right?
have to use option
Yeah, but anybody
B.
else can use option B if you so desire.
If they want to, yes. If they so desire, they can. I think option B, it's a little bit more of a process compared to option A. The difference between the big difference between option A and option B entities have to provide their kind of own estimates of the allowed amounts. So that's including inpatient and outpatient services for the specified years. And so specifically between July 24th, 2008 up to October 4th, 2024.
So in those situations, would they actually have to dig out and find how much the claims were worth, or just get the number of claims that they filed with Blue Cross? And then the idea is that whoever is assisting in this settlement process is going to go in there for the option A or the option B participants and then figure out exactly how much their numbers show you were paid versus what you should have got paid according to the plaintiffs in this case, right?
Yeah, so essentially they're going to calculate the amount of the covered services. So covered services meaning healthcare services, equipment and supplies covered under the individual's commercial health benefits product administered by any of the settling Blue individual plans. So essentially they would have to gather the data for their inpatient services and their outpatient services for those years, and they would kind of accumulate the estimates, and then that would be the amount that they would kind of claim when they submit their form to the administrators.
Yeah, but option A is pretty simple. If you don't fall into one of those categories, if you're not in one of the states that Moises mentioned, or if you have been in existence for the entire time period, you can simply say, here's who we are, you figure it out. And then the settlement administrator would apply these various formulas to figure out how much you're entitled to. So that's why I think, a lot of people are asking us, Moises, do you need an attorney or consultants to help you? And I don't know, probably not. Wouldn't you agree?
Probably not. I think the important thing to note, especially for the option B facilities, is to have the documentation, to have the data to kind of support your claims. Essentially, the rider form itself recommends to include any Excel spreadsheets with all this information, just in case the administrators have any kind of questions of how you calculated this data. Also, if there's any kind of dispute, you can kind of provide, hey, this is the data that we collected. This is kind of how we kind of determined this is how much we should be getting money, how much money we should get back.
And you're entitled to, under either of those options, to review what they're proposing. If you don't like it, you could theoretically object. But I think that it's a relatively straightforward process if you want to participate. So you don't want to dawdle on it, because if you're option B, it's going to take you a little more time to figure it out. Most option A participants in the settlement could file it tomorrow. It's all basic demographic information. At that point, you get your claims in before July 29 of this year. The fairness hearing happens that day, and then you wait for any disputes to be resolved or objections to be ruled on. That could take a while because, first of all, the court has to make a decision, and the court may say, I need some time to think about this. And then theoretically, there could be appeals or other objections. But once the settlement is finally approved and they determine what your share is supposed to be, then you could decide how you want to get it paid, by check, by Venmo, by PayPal, a special kind of MasterCard, or, just have the money wired to your ACH. So, probably looking towards the end of the year, at least, before you could see some of this money. On the other hand, if you don't file a claim, then you're not going to see any of the money. So that's why we wanted to get this word out. If you haven't heard about this, take a look at that website. You can always call us, but I think it's pretty self-explanatory in terms of how you file this. So wouldn't you agree, Moises?
Definitely. And if there are any other questions, you can call us. But there's also a hotline to call the administrators. You can always email the administrators as well, just to get more information. And as Dan mentioned earlier, there's webinars for both the providers and for the professionals. So
yeah, and I think that they want to get this settled. You say, oh, the plaintiffs will keep appealing it forever. Yeah, if they do, then they're not going to get their fee award. So I think that this is our guesstimate. It's going to have some resolution. You should get some money by year's end. And depending on your size, how long you participated, how badly the claims administrator thinks that Blue Cross may have acted in terms of anti-competitive conduct, you could get a substantial amount. So just wanted to let you know about that. And again, if you have any questions, you could always give us a call, but take a look at that website. Thanks very much.